Hi everybody, my name is Adil Mangalji and this is Elizabeth Long.
Hey guys!
We're from the firm Long Mangalji, a Canadian immigration law firm. As many of you guys have heard, weed is now legal here in Canada. And although this is a good news story for a lot of people, it did come with a lot of new legislation that's going to have major effect on immigrants here in Canada. And we're going to talk to you a bit about what changes are going to be coming.
So let's get into it. Essentially, there were two bills that were passed into law very recently. The first bill is called the Cannabis Act. And what that bill did, it did legalize the possession of legal cannabis under 30 grams. Let me repeat that, legal cannabis under 30 grams. But on the same act, it also set harsher penalties for other cannabis-related offenses. At the same time, another act was also passed, and that act raised the maximum punishment for driving under the influence, DUIs, to 10 years imprisonment. So, how does that affect you or other people you know? Well, first of all, let's talk about foreign nationals. Foreign nationals are anyone who are not Canadian citizens or permanent residents. And so if you might want to come to Canada to visit, to work, or study, you're not a Canadian citizen or permanent resident, you're going to be a foreign national. So for foreign nationals, possession of under 30 grams of legal cannabis is legal, okay? But possession of over 30 grams of illicit cannabis, they're offenses. So what is legal cannabis and what is illicit cannabis? Illicit cannabis is defined under the Act as any cannabis that was sold, produced, or distributed by a person prohibited from doing so under this Act. Well, guess what? All persons under the Act are prohibited from doing so unless they have been allowed to by a province under a provincial act, okay? So the question, if you had possessed cannabis outside of Canada, whether that would be illicit, it's up there. It very well could be interpreted that is illicit cannabis. So even if you possess under 30 grams of cannabis outside of Canada, that could still be found to be illicit cannabis.
So I have a question.
Yeah.
If an individual had used weed overseas, just recreationally, and had come to the border and was asked whether they had used weed, would they be in trouble now that it's legal in Canada?
So, first of all, it's not whether you've been convicted of something overseas, it's whether the officer has good reason to think that you've committed an offense overseas that makes you inadmissible to Canada. So if you tell the officer that you have actually committed the offense of possessing illicit cannabis, then they would very well find you inadmissible, okay? What happens if you are found to be inadmissible? Well, you can apply for a temporary resident permit to allow you to come to Canada on a temporary basis. Or if it's been 5 years after your sentence has been served, then you can actually apply for the permanent rehabilitation. Now, for these offenses, if it's been 10 years since your offense and your sentence has been served, then you may not even need to have to apply to rehabilitation if you only have one offense in your life. You can be deemed rehabilitated after 10 years.
The Cannabis Act is also going to have serious consequences on permanent residents here in Canada. Essentially, if you're convicted of possession of over 30 grams or of having any amount of illicit cannabis, and you get a sentence that is 6 months or more, you are going to be determined to be criminally inadmissible to Canada you're going to lose your permanent resident status, and you're going to have no place to appeal this. You can't go to the Immigration Appeal Division. This is extremely serious because the Immigration Appeal Division is where you're allowed to plead all of your humanitarian and compassionate factors. So you can say things like, I have children here in Canada, I have a job here, I have a business, I have a home. The only place where you can plead this is at the Immigration Appeal Division. However, if you get 6 months or more, you won't even be allowed in the door of the Immigration Appeal Division.
Okay, so now let's talk about DUIs, driving under the influence. So, if you are a foreign national and you have been convicted of a DUI, with the new law, it has raised DUIs to another level of criminality called serious criminality. What that means for foreign nationals is if you're coming in and you have a DUI in the past, it doesn't matter how long ago it occurred, you have to either apply for a temporary resident permit or apply for rehabilitation. There is no more deemed rehabilitation for you. Even if you had one DUI and it happened 20 years ago, you still have to now apply for a temporary resident permit or rehabilitation.
It's also going to have major consequences for permanent residents. All driving under the influence offenses are now serious criminality, as Elizabeth had explained. So how it's going to affect you is really going to depend on whether you were convicted in Canada or whether you were convicted for an offense overseas. If it occurs within Canada, what's really going to matter is the length of the sentence that you get. Again, no matter what the length of the sentence is, you are going to be criminally inadmissible to Canada. However, if your sentence is under 6 months, you will be able to go to the Immigration Appeal Division and plead humanitarian and compassionate factors. However, if something serious happened, if somebody was hit or hurt, and you get a sentence that's more than 6 months, then essentially you have no right of appeal and you'll essentially lose your permanent resident status. Even more problematic is if the offense occurs outside of Canada. If you're a permanent resident and you're traveling outside of Canada and you get a DUI, you essentially now will be deported, you'll lose your permanent resident status, and you will not get an appeal to the Immigration Appeal Division.
Okay, so Adam, let me just clarify this. If I get a DUI in Canada, let's just say I'm driving down the road and an officer stops me, okay? I haven't run down anyone, I haven't run into a bus stop, I'm just driving down the, they get me. What happens then?
Okay, so essentially, if you are convicted of it, you will have been found to have serious criminality. It means that you do lose your permanent residency. However, what's going to matter is what sentence the criminal judge gives you. If you get more than 6 months, you can't go to the Immigration Appeal Division. You essentially lose your status and you will be removed from Canada.
Okay, so if I get over 6 months in Canada, I am automatically deported. What if I'm in Napa in California and I'm enjoying the wine and I drink a little bit too much and I drive down the road, I don't hit anything, but the officer stops me and I get convicted for DUI. What happens then?
Then the immigration consequences are extremely harsh for Canada. Essentially, if you are convicted overseas for a DUI, it's considered serious criminality in Canada. And if it is done overseas, no matter what the sentence you got was, you are not allowed to appeal it to the Immigration Appeal Division, and essentially you lose your status here in Canada. So if you're going to Napa, make sure you have a designated driver.
Right. Okay. Well, guys, that's all we have for today. We hope you've learned a little bit. If you have more questions and if you feel like any of this might apply to you, please feel free to contact us. Our information is here on the screen. Okay, that's it. Take care, guys. Stay safe. Bye.